Hi, this is Victoria Nalule, and here with me again is Professor Peter Cameron and Braddon. In the first video, we tackled the reasons as to why we need international arbitration, and also they discussed the things to consider when drafting an arbitration clause. In this video, we'll talk about the set of arbitration, and they will tell us why is it important to choose the set of arbitration, and also they will briefly take us through the typical steps in an arbitration. But before we start, I would like Professor Cameron and Braddon to briefly introduce themselves again. Professor Cameron.
Hello, I'm Peter Cameron. I'm the Director of the Centre for Energy, Petroleum, Mineral Law and Policy at Dundee and Professor there, also an arbitrator and expert witness in many cases. Nice to be here.
Braddon.
And I'm Brandon Malone. I'm a lawyer and arbitrator based in Edinburgh and London, and I'm the chairman of the Scottish Arbitration and a co-director along with Peter Cameron of the International Centre for Energy Arbitration.
So in our first video, you took us through international arbitration, why is it important? And then in this one, we want to discuss more on the steps taken in an arbitration, and also to go further into the set of arbitration. Why is it so important to choose the set of arbitration? So we'll start with the set of arbitration. Why is it important?
Well, it's important to get the seat of arbitration right for a number of reasons. In the first place, the arbitration law of the seat is the law that's going to govern the arbitration. And in particular, its mandatory rules are going to govern the arbitration regardless of what the parties may agree. So for example, if you select Edinburgh as the seat of arbitration, your arbitration will be governed by the Arbitration Scotland Act 2010. If you pick London, then the Arbitration Act of 1996 is going to apply. And the courts of the seat will have a supervisory jurisdiction over your arbitration. So it's important to understand their attitude to arbitration. It's also important to understand any irregularities, any peculiarities of a seat that you pick, because some regimes can be pretty restrictive and can include, for example, rules about who's entitled to represent you in an arbitration. In Scotland, for example, we have an open regime. There's no restriction on who can represent a party, but some seats will say that you have to be a lawyer registered within that seat before you can appear in an arbitration. Now that can radically increase costs because you're then automatically involving multiple sets of lawyers. They may specify the rules to be followed, which may be in conflict with an institution that you've picked. It might specify the language of the arbitration, for example. There might be technical rules as to the execution of the award. So for example, the seat may require that an award has to be executed in the location, which again can add to expense if you're going to have to fly the tribunal to sign the award in the seat. And it can even go to the arbitrability of the dispute in question, depending what's an issue between the parties. Certain seats do not consider that certain types of disputes are arbitrable, and that can be very problematic if that's what your dispute's about. As I say, the courts will have jurisdiction, so it's important to select a seat where the courts are supportive, but also non-interventionist. You don't want a court that's going to interfere with you all the time. And you have to look at the mandatory rules of the seat and say, well, is there any conflict between what we've agreed in our contract or what is in the institutional rules and what these mandatory rules apply? Now, there have been a number of attempts to try and set out tests that people should look at to make sure they're selecting what we call a safe seat, a seat that's not going to end up in some sort of unexpected dysfunction with the arbitration. The Chartered Institute of Arbitrators have produced a set of principles called the London Centenary Principles, which are designed to help parties select a safe seat. They look at a number of criteria. So they're saying look at the law. They want a clear and effective modern arbitration law to help parties so that you know that the party's choices are going to be respected and it's going to be fair. They say look to the judiciary of the seat. You want an independent judiciary that's experienced in international commercial arbitration and respectful of party autonomy. Legal expertise, they say you should look somewhere where there is a legal profession which is experienced in international commercial arbitration. Education, they say that you should talk about, look at a commitment to education of all the key players. Are the judges trained? Do they look to educate their lawyers in arbitration? Right of representation, there ought to be a right for parties to be represented by the representative of their choice, whether from inside the seat or from somewhere else. Accessibility, some countries can be difficult to get to, can be difficult to get into in terms of visas. Do they have effective facilities? What are their ethical norms? And enforceability, is your seat party to, for example, the New York Convention, so that you can have this enforcement around the world. And finally, is your tribunal going to be immune from suit? And that certainly we've seen issues with recently, where we've had arbitrators, individual arbitrators coming under fire from local courts simply for exercising independent discretion. So those are a lot of the factors that you consider when you're looking for a seat. Now, certainly there are a number of emerging seats that perhaps would find it difficult to tick all of the boxes in terms of experience of international arbitration, but are nevertheless very safe in all other respects. And really, I don't think it'd be an exaggeration to say practically every major city in the world at the moment is trying to become a centre of arbitration. It's a booming business. So there's a lot of choice there, but there's a lot of pitfalls as well. So it's very important to get it right.
All right, Professor Cameron, anything to...
Well, Victoria, that was very comprehensive. So I think just some very minor additions to those remarks of Brandon. As he pointed out, individual arbitrators can find themselves subject to legal proceedings for behaviour that might be considered to be normal in arbitration, but according to the rules of the seat, the law of the seat would not be. And Dubai is an example of that, which has recently changed this law. But if you were dealing with a dispute in Dubai, until fairly recently, there was a risk that you might find yourself subject to a suit that would be about possibly rather large amounts of money for the exercise of your independent judgment. And that's been changed, but that's the kind of thing that you have to keep an eye out for. Is there anything in the local law that really you should be wary of? And probably the other thing just to underline is enforcement. Is there anything in the law of the seat that is going to give you a problem in enforcing an award, because you hope that there will be an award that leads to a practical outcome. So if there's something that will stop the enforcement or damage it in some way, it means that the whole process, which has probably taken quite a long time, has been wasted for at least for the winning side. And remember, this is an adversarial process. So basically, you do want that award to be enforced, and the losing party might well be in the mood to challenge it.
Okay, thank you very much, Professor Cameron, and thank you very much, Brandon.